8585.
Good morning.
That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
That's me. Good morning, everybody, and thank you so much for tuning in to Vastola on the Law. I am Jeff Vastola, and I am your host here every Saturday morning from 7:30 to 8 to give you free legal advice. That's why I'm here. And you just heard the number to call into the station if you are a radio show listener. This show airs every Saturday morning on 8:50 a.m., and they have a toll-free number where you can call in to be a part of the show with me. That number is 877-850-8585. Call that number, put you live on the air. Just mind your manners. I don't want to hear the names of the people that are making you angry or that you want to sue. But I will do my best to answer your question right here and right now. If I'm not able to do that, if I feel like I have to do some research to give you a better answer, then that's exactly what I'm going to do. And I will give you that better answer the following week. All you have to do is tune in the following week, or if you miss it, and there's my beautiful mom. She's on Facebook Live, which you can do, by the way. If you want to be a Facebook friend of mine, then Facebook will give you a notification that I've gone live every Saturday at 7:30, and you can watch on Facebook Live and type in comments. Good morning, Mom. How are things in Tennessee? But if you missed the show, if you've asked a question from a prior week and you slept in or you had something to do and you couldn't hear the show, then good morning, Don. What you can do is you can go to my website and you can go to the page where we upload as a podcast the show from that particular Saturday morning, and you can hear the answer to your question. Or you can always just call me and say, hey Jeff, I missed the show. What was the answer to the question? And I'll do my best. Now, if you want to reach me anytime, 24/7, that includes the weekend, that includes the evenings, call me at 833-VASTOLA. That's a toll-free number, forwards to my cell phone. 833-VASTOLA is 833-827-8652. I will do my best to answer that phone. If I don't, then leave me a voicemail message and I will get back to you as soon as I possibly can. If you want to learn more about us, me and the people that work with me at my firm, go to vastolalegal.com. Uncle Jeff, good morning. Nice to see you from Buffalo. Vastolalegal.com has all kinds of information about our firm, about me. You see a lot of bragging these days on the highway. I limit my bragging to our website. If you're interested to see what kind of results we've had, there's all kinds of results there on the website. And if you're interested in talking to me about a case, then of course use that number 833-VASTOLA, and I'm happy to talk to you anytime. Really, really excited because we're getting very close to our very first Vastola free legal seminar. I've done this once before, but it wasn't really the same thing, so I'm calling this one the first one. About 10 or 15 years ago, I did it with a television station, and we actually did it at the station, and it was really neat. Television station was obviously able to promote it. This time around, I'm doing it all on my own, with the exception of some very special guests. I have an insurance expert coming, I have a health expert coming, and I have a elder law and estate planning expert coming. They're all going to be on a panel of sorts with me. We're all going to give certain presentations, and we're all going to have breakout sessions where you can have private one-on-one consultations and speak to these various experts in their fields, and all of it's free. It's a free legal seminar. I'm calling it a free legal seminar because, of course, that's the only thing that I can offer you, but some of the information there is not just legal. It's health, it's insurance, which isn't always legal. So we encourage you to attend. It is free. And it's at the Embassy Suites Hotel on PGA Boulevard. It's from 1 to 4 on April 27th. It's free. And more importantly, we're going to have giveaways. And it's not really a raffle because you don't have to pay to get a raffle ticket. When you walk in the door, we're going to give you a raffle ticket for free. And we're going to have lots of prizes. Not to suggest that everybody's going to get a prize, but we really have no idea how many people are going to attend this first free legal seminar. And if there are only a few people in attendance, then chances are everybody's going to walk away with a prize. One of the things that I'm very intent on doing, and I spoke with my friend Jim at Tequesta Tire just yesterday about this, and I want to give props to Tequesta Tire because they're where I get my tires, and they're doing us a solid here. I'm going to contribute a certain amount of money to a set of tires, and those tires, that voucher will be good at Tequesta Tire, and you guessed it, Tequesta, for a free set of tires for somebody that needs them. So if you're listening to my show, or if you're listening to my show and you know somebody that really needs a set of tires but can't afford them. That's the key. Okay, that's the key. If you show up in a Bentley, I'm not going to give you the certificate for a free set of tires because the assumption is you can afford them. What I'm trying to do is I'm trying to find somebody that can't afford a set of tires but really, really needs them. So that's something that we're going to try to do at the seminar. I'm being distracted by a fly that's flying around my head. I apologize. But and so a couple things that we are very specifically going to do at this free legal seminar is we're encouraging everybody to bring your insurance policies, your homeowner's insurance policy, your automobile insurance policy, because not only myself, but the insurance expert that I'm bringing, we are going to sit down with you and look at your declarations pages and explain them to you if you don't already know it. If you're in the insurance industry, or if you're in the legal industry, or if you're just somebody that knows insurance, then obviously you don't need that. But I find that most people don't really understand their insurance policies and how the different types of coverages are there to protect them. And most importantly, just how many types of coverage are optional in the state of Florida, and oftentimes people don't have it. Almost every day in my legal practice, I am toiling with some kind of an insurance issue, and it's oftentimes some kind of an issue where somebody, either my client or perhaps even the defendant, the other side, doesn't have the right kind of coverage, and what are we going to do about that? So I'm trying to help people avoid those pitfalls. So bring your insurance policies, the declarations pages specifically, to the free legal seminar, and you will get some good free advice on how perhaps you can strengthen your policies to make life safer financially for you. The other thing that we're going to be doing is towards the end of the seminar, really in a way to make sure that the people that whoever I give a free set of tires to are in need of that, is we're going to go out into the parking lot, and I'm going to bring my tire tread depth gauge, and I'm going to show people how to measure your tire tread depth. If you're not already aware of that, some people are aware of it, and so obviously you wouldn't need to go out into the hot sun with us and do that exercise, but I'll be showing people where the wear bars are on their tire, which is a dire warning. If your tire tread gets down to the wear bar, then it is absolutely time to trade in the tires and get some new tires. My best advice is to get new tires before you get to the wear bar, because the wear bar is meant to be kind of last minute. But I'll be showing people how to feel for the wear bar, and then of course showing them how to do their own measurement on the tires. And if I find a worthwhile candidate, then I will be giving away a certificate for a free set of tires at Costa Tires. So anyway, that's the free legal seminar. Sorry that I went on and on and on about it, but I'm pretty excited. It's April 27th. It's coming up in just a couple of weeks, about a week and a half, and we hope to see you there. If you are able to, please go to the website and do like a pre-registration just to let us know you're coming, because at this point we have no idea who's coming other than our friend Dawn, who listens to the show every weekend. So thank you, Dawn, for that. At least we're going to be seeing you in person. So my topics today, if you weren't already aware, Florida Supreme Court issued a ruling back on December 31st of 2020 saying that as of May 1st, 2021, Florida is now going to follow the federal standard for summary judgment. Now, maybe that means nothing to you, but if you're an attorney in the state of Florida and you handle trial work, it means a lot, because up until May 1st of 2021, the standard in Florida to obtain a summary judgment was incredibly difficult. The bar was set so incredibly high, and all of the case law interpreting the rule up until then kept kind of mounting on top of itself to say the threshold is up here. It's not somewhere down here. The federal standard is somewhere down here, and so Florida is now going to drop its threshold for a party, either a plaintiff or a defendant, to obtain a summary judgment in a much easier fashion than it used to be. Now, understand, if you don't know what a summary judgment is, it is an opportunity for the judge to throw the case out before it actually gets to the jury. That's layman's explanation of what is a summary judgment. They get filed somewhat frequently, and I have to explain it to my clients when they're filed, because I have to then do what's called a reply memorandum, do a bunch of research and a bunch of writing, and respond to their motion to say these are all the reasons why the motion should not be granted. I'm actually drafting one, not as we speak, but I was at my desk yesterday and throughout the week working on a reply memorandum to a motion for summary judgment. They're pretty common. But the ability for a party to throw a case out was much more difficult, obviously, leading up until May 1st of this year, because you basically had to show to the court, after a reasonable time for discovery, so that the parties could gather their evidence and they'd be able to show the court something, that, for example, if it's the defendant filing the motion for summary judgment, they would be presenting the issues to the court to say the plaintiff simply cannot prove this case. They do not have the evidence to prove this case. And if the judge agreed, then the motion would be granted and the case, at least with regard to that party or those issues, is thrown out. One of the things that we do as a plaintiff, and I only typically ever represent plaintiffs, so that's why I say it that way, is in an automobile accident case, if I take the deposition of the defendant driver and the defendant driver admits fault or admits enough that I feel I can prove that fault is not an issue. For example, if they don't say, it was my fault. Sometimes they do that. It was my fault. I was very sorry. That does happen, believe it or not, every once in a while. But sometimes people aren't willing to admit the fault, but they're willing to admit to what they were doing in the car. Well, I was looking down at my stereo, or I was sending a text on my phone, or I was doing something, and I wasn't paying attention. Oftentimes that's enough for me to file a motion for summary judgment on the issue of liability. See, when a plaintiff brings a claim for injury in the state of Florida, you essentially have to prove three things. You have to prove the liability, meaning who's at fault, causation, meaning did this incident cause the injuries and the damages that you're complaining about in your lawsuit, and then ultimately damages. What are your damages? So that first issue of liability, who's at fault, is something that we try to eliminate if we can. Because if we don't eliminate it through a summary judgment, then ultimately it's for the jury to determine who's at fault. And sometimes the jury can surprise you. Or the jury can bring in what's called comparative fault and say, well, we think it's a 50-50. In a case where a jury decides that fault is a 50-50 and they award $100,000 to the plaintiff, well, guess what? The plaintiff only is entitled to the $50,000 because you don't recover for your own negligence. So in a case where a defendant has admitted fault or has admitted to doing something in the car where they weren't really paying attention, I'll file a motion for summary judgment on the issue of liability, and oftentimes they're granted because I have the testimony of the driver and the judge agrees and says, yeah, liability is not an issue here. So it takes that issue away from the jury so that you don't have to worry about it at trial. Like I said, though, oftentimes these motions are filed to completely throw the case out entirely, and that's what the defendants oftentimes try to do, is they try to throw the whole case out. But anyway, in case you're interested, Florida Supreme Court opinion, it is SC 20-1490 if you're interested in reading it yourself. Essentially, the Florida Supreme Court highlighted three reasons why they want to align itself with the federal standard. There's, at any given time, there's the federal court system operating at the same time as every state's court system. And as you can imagine, the federal court system applies federal law, federal issues uniformly throughout all 50 states. However, there are physical federal court locations in every state. At the same time, however, each state has its own court system. Every county has its own courthouse, typically, if it's a big enough county. And state issues and state law are being decided in the state court cases. Oftentimes, however, the federal law, or the state law, I should say, mirrors that of the federal law. Not every time. States are given autonomy, pardon me, to govern themselves, but oftentimes the state law will mirror the federal law. And in this case, the Florida Supreme Court acknowledged that Florida law started going off on that direction, and federal law was going that direction on summary judgment. And the Florida Supreme Court said, you know what, we need to go back to where federal law is going on this, because it's becoming the wild, wild west out there with regard to motions for summary judgment, and this is not what it was meant to be. So for three reasons, I just cover them very quickly. Florida courts have repeatedly declined to recognize the fundamental similarity between a motion for directed verdict and a motion for summary judgment. That requires more explanation, which, if anybody's interested, then I'm happy to give it. But the Supreme Court concluded, that's the federal court, the inquiry under each is the same, whether the evidence presents a sufficient disagreement to require submission to a jury, or whether it is so one-sided that one party must prevail as a matter of law. If it's a significant disagreement, then it must go to the jury, because that is the purpose of a jury trial. The purpose of a jury sitting there and listening to the case is to decide questions of fact and the dispute. Who wins the dispute? That's essentially the jury's job, but the Supreme Court of the United States is saying if there is no true disagreement, if there's no evidence to support the claim, either the plaintiff's claim or even a defense, an affirmative defense can be subject to a motion for summary judgment as well, then you can take that issue away from the jury because there's nothing for them to decide. That's essentially it. The second reason, Florida courts have required the moving party conclusively to disprove the non-movement's theory of the case in order to eliminate any issue of fact, and that's just not the way it was ever supposed to be. The Supreme Court of the United States explained the burden on the moving party, which is the party that files the motion for summary judgment, may be discharged by showing, that is, by pointing out to the district court that there is an absence of evidence to support the non-moving party's case. Now, this is important. Provided that there has been adequate time for discovery, the Supreme Court of the United States suggested that that is the burden. The reason why you have to have adequate time for discovery is because you have to give the non-moving party an opportunity to gather their evidence. Discovery includes written questions that the other side must answer. Sometimes, very rarely, written questions can be sent to a non-party, and the non-party can be obligated to respond. That's very, very rare. We don't see that very often. But written requests for documents and things, photos, videos, whatever you may have, receipts, that's called a request for production. You can do what's called a request for admissions, where it's a written statement, and the opposing party has to respond to that written statement in writing to admit or deny, or file an objection. And then, of course, you have depositions, very, very common for both sides to take depositions of important witnesses. Of course, the parties are oftentimes deposed, but important witnesses, people that have some knowledge about the case. Depositions are fundamental in bringing or defending against a motion for summary judgment. That's oftentimes where you find most of your evidence to support or refute the motion. I've been talking a lot. I realize I haven't given out the phone number. If you're listening to the show on the radio and you have a question, if you have any kind of follow-up on what I've been talking about, dial 877-850-8585. That will get you onto the show with me live, and you can ask me anything you want. Even if you just have a comment. It doesn't have to be a question. You can have a comment on what I'm discussing. But while I wait for a telephone call, and I see that Patrick Canavan is watching. Good morning, Patrick. I have several cases from my Florida Law Weekly that I wanted to talk about. I don't very often get an opportunity to talk about these things because I usually get caught up on something else. But I have what's called a special setting for a jury trial. I'm really, really excited about that because I haven't been to trial since COVID. And neither have most lawyers in the state of Florida. Very, very few lawyers have actually been able to get to trial. But on May 3rd, on Monday, May 3rd, I have been told, I was told, I believe it was yesterday, by the court, that my case is now special set to go to trial, number one, on May 3rd, Monday. So I'm getting myself ready for the first jury trial that I've had in over a year. And like anything else, you can get a little rusty. So I've been listening to some CLE audio tapes. That's continuing legal education, which I have to do to keep my hours current. But I purchased a CLE audio on trial refresher type of thing. And one of the things that was covered so far, I haven't finished it, but one of the things that was covered was jury selection and what's called a Melbourne challenge in the process of selecting a jury. And essentially, what the Melbourne challenge requires is that if a lawyer is going to try to eliminate a potential juror from the panel of potential jurors, and the other attorney suspects that there might be a race motive for exercising a peremptory challenge, for example, if you have an African American plaintiff and the defense attorney tries to strike an African American member of the panel and does not have a race neutral and non-pretextual reason for doing so, then the court can deny the peremptory challenge. Now, oftentimes peremptory challenges are to be used at the attorney's whim, but ultimately the court, as time goes on, realized that lawyers were using peremptory challenges to eliminate potential jurors of the same race, or sometimes the same religion, whatever it may be, protected classes. And so this is a case that's in here called Hialeah Hospital versus Joshua Missius Hayes this is a wrongful death medical malpractice claim down in the Miami area, and the court ruled that when the defense attorney for the hospital tried to eliminate a black potential juror from the veneer panel, and the attorney was asked, according to what's called the Melbourne Challenge. The Melbourne Challenge comes from the case called the Melbourne case, where the attorney was told, okay, well, if you want to exercise a peremptory challenge on this potential member of the jury, I need a race-neutral reason, and it can't be pretextual. So it's a non-pretextual reason for the peremptory challenge. And unfortunately, the attorney didn't give a decent enough explanation as to why he or she was trying to eliminate this potential jury member. And the court concluded that it was not a race-neutral peremptory challenge. And so the court did not allow them to strike that member. The assumption then is that that person was selected to sit on the jury. There was obviously a verdict in favor of the plaintiff because it's the hospital that filed the appeal, and the appeal is finding all kinds of reasons to file the appeal, one of which is saying, well, the judge should have allowed us to use the peremptory challenge on this juror. That juror never should have sat on this panel, never should have sat on this medical malpractice case, and ultimately the verdict needs to be set aside. Wow, that is a very active bird. But the verdict needs to be set aside or reversed because they should have been stricken, never should have been there. Now, if the appellate court agreed, then that's exactly what would have happened. The trial would have gone poof, it would have been reversed, would have been set back to do it all over again. But the the appellate court agreed with the trial court and said, we agree, there was no abuse of discretion here, and so therefore the trial court's ruling was upheld, and as was the verdict. So, if you are ever participating as a potential juror, and you see stuff like that going on, then you'll be at least somewhat educated on what is a Melbourne Challenge. Now, oftentimes a Melbourne Challenge happens outside the earshot of the veneer panels. Oftentimes they're excused. You're in the hallway while all of this stuff is going on. Good morning, Uncle Mike, Michael Rads. How are things? You in Illinois or Colorado? Or somewhere else? It's like Uncle Traveling Matt, my Uncle Mike. So here's another case, and what I wanted to discuss with you quickly is what's called an in-camera inspection. And the reason why I found this case interesting is because not only is there a case right out of our 4th DCA dealing with a trial court's error in not conducting an in-camera inspection, but just this week I attended a hearing, and the very same judge from our 4th, now this was the trial judge that made the decision, but of course it's the 4th DCA, the appellate court, that's ruling on it. But this very same judge ruled at my request that an in-camera inspection should be done. So in this case, let me bring everything around. In this case, there was a suggestion from the attorney representing the plaintiff that the production of the medical records without them being inspected by the court would be a violation of the patient's privacy concerns, because they included mental health records that had nothing to do with the case, and that's pretty common. I had a case very similar to that, where a client's medical health records were so off the charts irrelevant to the underlying personal injury case that the judge did the right thing and said, yes, those are not coming in. Those are not even discoverable to the other side. The other side is never going to see those records. That's the purpose of what's called an in-camera inspection. The lawyer that is seeking the protective order has the records, has seen them, and has said, these, in my opinion, have nothing to do with the case, and they should not be disclosed to the other side, and certainly shouldn't be used in the court, in the trial. So what you do is you file the motion for protective order, and you then submit the documents to the court for an in-camera inspection. Now, where they derive the term in-camera, I don't know. I suspect it's Latin. Most of our terms are Latin. But that allows the court an opportunity to look at the documents before ruling. And so in this case, the trial court was reversed because the attorney asked for an in-camera inspection. The court denied it and required disclosure of the records. That's just not the way it's supposed to be done. And so the in-camera inspection was granted in my case. So, and that just happened this week. Let me see, I've got one more case to talk about here, and then I'll be wrapping up the show. Sharina, just let me know when I'm getting close, because I cannot see the timer on either one of my computers for some reason.
2 minutes.
2 minutes, okay. That gives me enough time to talk about this case. It's a really interesting case out of the 2nd DCA, which is over on the west coast of Florida. This is Sarasota County. This is a case called Bridget Jackman and Kieran Jackman versus Catherine Swartz and Richard Swartz. And the case was an invasion of privacy case, which they filed with a complaint seeking the remedies of most likely monetary damages, but also they sought what's called an injunction. Now, the last couple of weeks I've been talking about various remedies that are available to people if you have been aggrieved or you've been harmed. You don't just have to ask for money. Most oftentimes that's what people are asking for, but it doesn't have to be money. It can be some form of an injunction. And as I mentioned before, injunctions can be where you are asking the court to force the other side to do something that they are not doing but they're supposed to be, or to stop doing something
1 minute.
that they are doing and they're not supposed to be doing. And in this case, that's exactly what it was. They were seeking an injunction to get these neighbors to stop videoing them from a 25-foot high security camera that one neighbor put on their house looking down into the backyard of the other house. The trial court denied the injunction, saying, sorry, we're just going to have to wait for your trial, which essentially meant that those neighbors are going to be subject to the neighbor's video camera because they had a boundary dispute. So one neighbor said, well, I'll stick it to you. I'm going to watch
30
everything
seconds.
you do. Violation of privacy. The appellate court said it was trial court error not to grant the immediate injunction and to shut down that video camera. Anyway, thank you so much for listening. If you would like to talk to me about anything at all, 833-VASTOLA. That's 833-827-8652. Thank you for watching. Don't forget about our free legal seminar, April 27th in Palm Beach Gardens at the Embassy Suites. Have a great weekend. God bless.